Okay, it is Monday, April the 25th, 2022. And yes, it's kind of early in the morning for me. It's about 8:30 p.m. Central Standard Time. I'm sorry, 8:30 a.m. Central Standard Time. And because I have something I need to do this evening, I thought I would issue the recording to you guys a little early this week. So I'm going to take the time to first of all say that I've looked at the grades. Most of you are doing pretty well. There are few of you who are not doing so well, but it's primarily because you haven't either haven't turned in assignments or you haven't. I don't know what's going on with you, but it's about four to five students out of the group that need to step up their game and get their grades. You know who you are. And I want you to, if you have any concerns or questions, reach out to me. Please do not email me. Please text me or call me so that we can discuss the issues. Because emails going back and forth for that kind of a situation doesn't accomplish much. So it's very important. Be aware of the fact that the course ends in a couple of weeks. It ends on the 10th. So be aware of that. And then I'm going to take time now and share my screen. Once again, finally, pay close attention to the comments that I put in the rubric about what you may be missing in terms of assignments or information that you did not complete. So let's share my screen as we enter into the course. Okay, here we are. All right, so let's start with the grade book. You will see here that I've completed grades for weeks 1 and 2. I've completed the live classroom submission, and there's one person who hasn't submitted something, can still submit it and get some points for it, but it's going to be late. The discussion is closed. I graded them already. And then your written assignment, there's about 18 assignments that have been submitted. 2 have not submitted assignments. So remember, at the end of this week, which actually end of week 3 is we're past it. You cannot submit assignments from week 1 to 3, except you can submit week 3 because you're still within the 7 days. So weeks 1 and 2, I should say, are absolutely closed off. Okay, because no one has reached out to me to let me know the reasons why you haven't. And just remember, this is week 4 as we start today. Written assignment, Fifth Amendment limitations. So I'll talk about that. The right to remain silent discussion. I will comment about that. And then you submit your live classroom lecture. Both of these are due. This one, the written assignment, as well as the submission for the live classroom lecture, is due by this Sunday, which is the coming up the 1st of May. Okay. All right, let's go over to the calendar again to bring it into perspective where we are, as I do every week. This is where we are. It says 7 o'clock, but I'm doing it now for you, so you'll have it in advance. The initial post is due tomorrow. The reply post is due Saturday the 30th. Okay. And then your written assignments, as I said, are due on Monday. That is your live classroom phrase and your written assignment. Okay. All right. Be aware that next week we will have 2 lectures. Remember, we'll have the one on Monday, which will probably be at the regular time. And then the one Thursday will also be at 7 o'clock. And the reason why we're having one Thursday as opposed to next Monday is because the course ends the next day. And doesn't make sense to give you a lecture. And I think you would agree with that. So we have two next week coming up. Okay. And absolutely, no assignments will be accepted after the 10th of May without exception, unless you've appropriately requested an incomplete. Do not request an incomplete of your dean or your advisor. Request an incomplete from me. You need to reach out to me. Reaching out to your advisors or your dean about an issue is really something that you should do after you've reached out to me. And remember, I said emails when you have an issue like this are not the best way to do it, because you want to be on top of it and get a response where we can communicate better to deal with the issues. My goal is to help each and every one of you to succeed, but I need also some assistance from you guys as well. Okay, so let's go to the course and let's look at first the announcement. So for week 4 announcement, the Fifth Amendment and government authority is the topic of discussion this week. Chapters 4 and 10 of the textbook have been previously emailed to you, so you should have those already. Topics like double jeopardy, the right to remain silent, and court case review, procedural due process, and knowledge check we will cover. These are some sources to help you. You click on these. So we're going to, again, go over this during this next hour. Okay. All right, so the lecture, it says 7, but you know we're doing it now. The discussion assignment, right to remain silent. Again, repeating, is due tomorrow, your initial post, and Saturday, your reply post. And finally, your written assignment, Fifth Amendment limitations, is due Sunday, as well as your key phrase. And remember, pay close attention to the rubric, the things I say in the lecture, and the module itself. Very important. So it's time for you to finish strong. And remember my motto, adversity is springboard to success. You know what that's about, because it is right here in front of you if you ever want to take time to take a look at that. Okay. So let's get right into the Fifth Amendment and government authority. Let's first start with understanding clearly what the written assignment is all about. So for this, you will discuss the limitations of the Fifth as it applies to this scenario that's given here. Okay, I'm not going to read the scenario, but you're going to go over it. Your responsibility is to submit a 2 to 3 page paper. Let me say this from the beginning. Many of you will write papers, but your content is not enough. If we say a minimum is 2 pages, or if we say 3 pages, as we had in some previous assignments, you will lose points for not having good content, not having enough. The purpose, so you understand it, of it is because we believe that in order to adequately address the issues that are laid out in the assignment, you must at least satisfy the minimum page requirement. I don't mind if you go over the 3, I don't care, but the minimum absolutely must be satisfied. That is double space, it's APA, citations in the body, and please, I keep saying this over and over and over and over again, cite the official court case. Don't cite Oyez or fine law. Too many students have been getting hit with that. And I've said it from the beginning. Always cite the court cases. Some of you have been in classes with me before, and you know that when it comes to citing cases, cite the official court case. And since these cases are U.S. Supreme Court cases, it should start out with a number. It should say U.S., and then there'll be another number. And then in parentheses, hear me good, parentheses, the year. That's the complete thing. That should be at least at the beginning of it. It doesn't have to be throughout the whole paper. But each case you cite the first time, it should be cited that way. Some of you have been citing just the name of the case. That's not adequate. Remember, we're dealing with APA, proper formatting, proper citations. And I just gave it to you a few minutes ago. So it's very important. You will lose some points for that. And you could have a perfect paper, but it will drop to the next level if you don't do that. Okay? Now, so in your paper, discuss the right to remain silent as it applies in criminal cases. You should know that the leading case for that is Miranda versus Arizona. And cite that case appropriately. I will be discussing it today. I've discussed it in previous classes. Support your ideas with appropriate case law. Again, citing those cases appropriately. Explain how you'd handle the demand by Jim's mother. If you do, provide some support for it. There is some case law that supports how you would handle Jim's mother's request. Describe how you would proceed, including how you would properly handle the Miranda when you continue to question Jim after arrest. I'll just say up front that you do not issue the Miranda warnings until, number one, a person is in custody. And what that means is they're not free to go. You don't have to use the words under arrest. But if you do, that's fine. That's a qualified way. At that point in time, if you decide to question that individual, you must issue the Miranda warnings. And we'll talk about them more in detail. Okay? Discuss how ensuring Jim's rights are protected and is essential to due process. And then, of course, cite credible sources, cases, law reviews, other places that you use. But please rely on the official court cases. Include a reference page and a cover page, double space. I wanted professional language with correct spelling, grammar, and punctuation. It's very important that you get that in, okay? All right. And please run your papers through Grammarly, checking the plagiarism list, because if you're above 25%, you're going to get a Grammarly hit, okay? And we don't want that to happen to you. All right, let's take a look at the grading rubric. Here it comes. As you know, if you don't have citations, appropriate citations, period, you're going to end up over here because it's incomplete, 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 no credible sources. And then if you don't meet the 2-page minimum requirement, you're going to end up losing, not for the whole thing, but you'll lose 50% of this section, professional language. So let's just discuss the first part. So outstanding discussion. We already kind of know what an outstanding discussion that I'm looking for. Several of you understood and got it from the beginning. Outstanding from all sections. And I would use this to say, as I read my paper before I submit it, I would say, did I submit the information outstanding on the right to remain silent. Did I cover the issue of Jim's mother's demand in an outstanding fashion with appropriate case law? Are you providing outstanding explanations of how to properly handle Miranda? Are you citing sources? We already talked about that. And then, is it at least a minimum of 2 pages with no spelling, grammar, or punctuation errors, should I say? That's it. All right. You have questions? Do not hesitate to reach out to me. Or I don't have to say this, but I'll say it again, is that it is going to be in the form of a Word document, not a PDF. Only one student has submitted a PDF written assignment this term. I said it from the beginning, and I think it says it down here. It should say it in here, but it's not. It doesn't say it here, but it should be a Word document. A Word document, not a PDF. Okay. So let's get to the discussion. So the right to remain silent, you're going to use this scenario. All right. And so in your initial post, discuss the strategies you use to set up the non-custodial interview. Do you issue the Miranda warnings during non-custodial interview? I already told you the answer to that, but it's no. What would you do to ensure that it remained non-custodial? When might the interview transition from non-custodial to custodial? I told you that a few minutes ago. Discuss when the right to remain silent applies and does not apply. I told you that. Support your strategy conclusion with constitutional case laws. Again, I don't generally require citations in the body of reference at the end, but it's a good habit to have. And then in your reply post, reply to another student's post. Okay. All right. So those are the assignments. Then your live classroom submission, you'll submit the key phrase that I'll give you during this lecture. And then your live classroom link, which you'll see by the time you see it, it won't have this. It will be changed to what the link will be as I converted it so that you can have it. And I will email it to you also. So we're going to talk about double jeopardy, the right to remain silent. All right. And then procedural due process. So let's talk about what double jeopardy is. Okay, first of all, the Fifth Amendment makes it quite clear that because of the fact that you have the courts to interpret cases, and the prosecution generally, listen to me, has one bite out of the apple. And when I say that, it says quite clearly the Fifth Amendment prohibits double jeopardy. And it states clearly, now you have to pay attention, nor shall any person be subject for the same offense to be twice put in jeopardy or life at limb. So the key thing that you need to understand before I get into further explanation is number one, at the state level, the prosecution can retry a case if it's a hung jury. They can retry a case if there is the appellate court, when there is an appeal and it comes back. But generally, the key thing that you should be aware is that the prosecution has one opportunity. If they try the individual under federal charges, that is not double jeopardy because these are different charges at a different level with different consequences. So let's get that clear up front. All right. So here we are dealing just a little bit with double jeopardy. So usually the issue of double jeopardy might come out with juvenile offenders. And because of the fact that if a juvenile is tried as a juvenile and then tried again for the same offense as an adult, it creates a problem of double jeopardy because it's the same case all over again at a different level. So let's read this. This application of double jeopardy was created in Breed versus Jones. That's where you would find it. And Gary Jones, he was only 17, which meant that he was still a minor. And he was determined to be delinquent in the juvenile court for robbery. So he was adjudged delinquent in the juvenile court. Okay. So the juvenile court concluded that Jones was not a good fit for post-adjudication treatment and waived him to the adult court. So they sent him to the adult court. All right. Jones objected and appealed through the state courts of California, but they upheld a waiver. He agreed to have his case adjudged upon the juvenile court record, and he was found guilty of robbery, but committed to the juvenile facility. So he appealed all the way to U.S. Supreme Court, and he said this was double jeopardy. Okay. For him to be adjudicated in the adult court and tried again in adult court. The Supreme Court unanimously, that meant 9-0, agreed that once the juvenile is adjudged delinquent in juvenile court, you can't go to the adult court. Okay, so get that fits with kind of what I said, and so it's quite clear that double jeopardy applies to juveniles and it applies to adults. There was a movie that I saw, and the name of the movie was Double Jeopardy, and it Ashley Judd of the Judd Singers was the star of the movie, and Tommy Lee Jones was secondary. He was actually her, I believe, her parole officer. And so here's what happened. Ashley Judd was found guilty of murdering her husband. Okay, and she served time, and she was released on parole. But while she was in custody and serving her term, she discovered that her husband was not dead, that it was a fake, and that she was set up. And in fact, she tracked him down and found him in another part of the country. I think it was New Orleans. And when she found him there, he had another identity. He had gotten married to, by the way, a close friend of the wife. Take that one there. And he had established a whole new life. Well, she approached him. And when she approached him, she was under attack after that by him, of course, because she knew that he was her husband and that he was not dead. Now, number one, she never divorced him. He never divorced her, to my knowledge, and they were still married. So anyway, here's the deal. She tracked him down. The parole officer, Tommy Lee Jones, found out that she was down there, and he went after her to find out what was going on with her. Well, the way the movie ended is that, first of all, number one, he tried to kill her. Her husband tried to kill her to just, because he wanted to steal remain in the situation he was in. He was very wealthy by this time. So anyway, and part of the wealth was because of the death benefit. And by the way, they had a son, so that money would go to the son, not to him, of course, because he's dead. It wouldn't go to the wife because she's in prison and she committed the offense. So she was found guilty of. So at the end of the movie, they end up at a location, and he tries to kill her, and then she ends up shooting him, and he dies. And the police come, and the police say, um, well, you won't be prosecuted because you've already suffered jeopardy for this crime of killing him. He's dead now, so we can't try you twice. And as a matter of fact, it could have been a self-defense case either also. But let's leave that alone. And let's just point out the fact that they couldn't try her. And all of the property reverted to her. And that was it. So the point of the matter is, it's a very good movie if you get a chance to watch it. I loved it. Um, and so here is a little video that you can watch. I'm just going to click on it. By the way, this is the Breed versus Jones entire citation. Remember I said how appropriately to cite them? See, there it is. Not just in the reference section, but in the body of the paper too. Let me see if this video is available, because one time it wasn't. Okay, good. Okay, so you can take time to take a look at that, and you get a good explanation of it. It's really short. Okay, let's just do it.
Double jeopardy is a procedural defense that prevents an accused person from being tried again on the same or similar charges and on the same facts, following a valid acquittal or conviction. If this issue is raised, evidence will be placed before the court, which will normally rule as a preliminary matter whether the plea is substantiated. If it is, the projected trial will be prevented from proceeding. In some countries, including Canada, Mexico, and the United States, the guarantee against being twice put in jeopardy is a constitutional right. In other countries, the protection is afforded by statute. In common law countries, a defendant may enter a peremptory plea of autrefois acquit, formally acquitted, or autrefois convict, formally convicted, with the same effect. The doctrine appears to have originated in Roman law, in the principle non bis in idem, an issue once decided must not be raised again.
Okay, obviously you probably couldn't hear because I had my headset on, but it's very general. You get a chance, you can go back and listen to it. It's only 1 minute and 27 seconds. But basically it said exactly what I said, that once you're adjudicated, you can't be adjudicated a second time. Okay. And remember, I explained the difference between federal and state. All right. And then here are just a few things, cases that you can take a look at yourself, but I'm going to share with you Palco versus Connecticut, and then you get more information about Palco, who was charged with first-degree murder, but found guilty of second-degree murder and sentenced to life. He appealed to arguing double jeopardy, and an 8-1 decision rejected his double jeopardy claim because double jeopardy was not a fundamental right like freedom of speech and did not apply to the states. That's the way it was, okay, in Palco. And Palco decision remained the law until 1969, when John Benton was arrested in Maryland, and he was found not guilty of larceny. but guilty of burglary and sentenced to 10 years. On appeal, it was overturned because jurors were elected in violation of the state constitution. The state tried to refile the charges, and Benton was sentenced concurrently. Benton successfully appealed his double jeopardy claim to the U.S. Supreme Court. The court applied the double jeopardy clause and said with Benton, since Benton had already been tried and found not guilty of larceny, he could not be tried again for that same charge. Therefore, the Fifth Amendment applies to state criminal law cases. So this was the federal application. This is the state. So as of 69, okay, double jeopardy also applied to state cases. All right. So those are just two cases that fit within that. All right. So let's talk about the right to remain silent. All of you should see that lady with her hand up, and it means what it says. And it really is probably one of the most clearest things. And so the key thing is, you know that the Fifth Amendment says that you don't have to incriminate yourself. And so out of the landmark case of Miranda versus Arizona, and by the way, this is not the appropriate citation. This is only part of it because it's missing the volume. But as you know, that as of the Miranda case of 1966, that you cannot question a person who's in custody, okay, until you warn them of their Miranda rights. And most of the time, the officers now read from a pre-printed card. They don't do it from memory. It used to be that way because if you're in court, you want to be able to testify in court that you provided those warnings from a pre-printed card, and then you could read those again. So, so you have to read it during the interview if the person is in custody. All right. So those are pretty much the way. So if you look at a scenario, the question is asked during the interview, the suspect mother arrived at the lobby and demands the police recognize her son's right to remain silent. You know where that came from. Your response to her in this lesson, you're going to discover the answer to that. So I already told you about the Miranda warnings. And you know what those rights are. Now, one of the things I should tell you that I know is that I had a law professor, and I always bring this to my students' attention because I had an inside track into the Miranda case. His name was Fred Inbow, and this was in 1975. And Professor Inbow shared with us that if you read the Miranda case, the full case, in the footnotes you will see them mentioning a book entitled Interrogation and Confessions by Inbow and Reed. And in this book were the techniques that were utilized by law enforcement across the country, including in this instance. Well, the United States Supreme Court, after going over the techniques and styles, decided that they were probably a violation of the Fifth Amendment of the Constitution and the individual's right to self-incrimination. And so the rights were given and came about. The right to remain silent. Anything you say can and will be used against you. You have a right to an attorney. If you do not believe, if you do not can afford one will be appointed for you. Do you understand these rights? So the individual must clearly, and that's just a statement of him, but you look at it very carefully. And the Miranda rights are not just procedural, but they're constitutional. if you look at the Dickerson case, which elaborates on it, one of the things that my professor unfortunately was not able to do for him was every year a issue came up before the United States Supreme Court after Miranda. He submitted an amicus brief, and that's what we call a friend of the court brief. And what it was is organizations or individuals who would submit briefs to the court who were not parties to the case to try to help the court to reach a decision about how to handle the issue or how to modify it. Well, he died before that happened, and it still hasn't happened as of right now, 2022. Okay, so I'm not going to read over this paragraph because I've already covered that with you when it does. So now, here is something that you need to know. If a person is subject to an interrogation and decides to exercise his Miranda rights, all questioning should stop. You can't ask them, are you sure? You can't do that. Okay? You cannot do that, period. But it says, however, a suspect who voluntarily comes to the department for questioning and is not under arrest, is not in custody, cannot assert the right to silence. They don't have to say anything. They just don't have to say anything. In non-custodial cases, silence may also be introduced as substantive evidence. Read the Salinas case. All right. It's a 213 case. When a suspect invokes the right to remain silent, it must be clearly expressed. Merely remaining silent is not an invocation of the right. But the point of the matter is, written waiver forms are often used to demonstrate a person understood their rights. But the waiver forms that are signed by individuals, they have to understand every word in that document. All right. The right to remain silent is a personal right and cannot be asserted on an arrested person's behalf. In other words, the person's mother cannot do it. The suspect has to do it. Okay? Now, there's a question about juveniles, but we're talking about an adult court. When the right to remain silent is expressed and questioning ceases, law enforcement should not reapproach the suspect. But if the suspect just comes on their own and says, you know what, I thought about it a little bit, I decided I want to talk. Then the suspect, it makes it quite clear, then allow the questioning to continue, and a fresh Miranda warnings are given according to Edwards versus Arizona. Now, let me say that that is a dangerous practice, but it's done. Now, one of the things that you should be aware of is many interrogations now, and I think most agencies now record them. When I say video record them is what I mean, so that you can see what's going on. And as a result, you can see when a person decides that. So it provides strength. Back when I was practicing, we didn't have that. Okay. So here are the actual citations for those cases that I was talking about. So always use these. Okay. See Miranda, 384 U.S. 436, and in parentheses, 1966. All right. Salinas versus Texas, 570 U.S. 178 213. All right. So it's an important aspect. Okay. Miranda rights. And then this is just a review of that. You can go over this yourself, but I'll just choose the correct answer. Which case established the right to remain silent? You already know. It's Miranda versus Arizona. Correct. Which case established that an individual cannot assert the right to silence? We just talked about that. Salinas versus Texas, the 2013 case. Which case established that merely remaining silent is not an invocation? That's it, Burgess. And you can go through and so forth. Which case established the right is a personal right, and you can pick. Is it Edwards versus Arizona, or is it People versus Houston? Let's try that one, but I don't think that's it. That's what I said. So it's actually this one, People versus Houston. Okay. And so you can go through all of those and you can learn more about it. I pretty much covered it. All right. So let's conclude with procedural due process. So what are we talking about when we say procedural due process? And a person is presumed innocent until proven guilty. And the idea is that, as it says here in the Coffin versus United States case, 1895 case, no man shall be condemned on a criminal charge in absence, because it was better to let the crime of guilty person go unpunished than to condemn the innocent. So in other words, the key thing is that we want to make sure that the rights of every individual, that is why I tell my law enforcement people, it's there not just for their protection as defendants, but it's also for the protection of law enforcement. I have represented individuals in my years who were law enforcement officers, and the procedural due process was on the other foot. So um, so procedural due process is derived again from the Fifth Amendment, where it says, no, you're not deprived of life, liberty, or property without due process of law. And then it was applied to the states in the 14th Amendment. Okay, so the due process clause um, um, makes it quite clear that individuals who are at trial are entitled to information concerning the charges against them, and that they have a right to an attorney, and that they have a right to question the witnesses. They have a right to file what we call a motion for discovery, to discover the evidence that is held by the prosecution. And once they receive that information, they can determine if they want to file motions preliminarily before trial to try to have some of that information not to be used at trial by filing what we call motions to suppress. Maybe the statement was done improperly. Maybe the evidence was seized in violation of the Fourth Amendment and without an adequate exception involved. Maybe the arrest was improper. Maybe there was no due process. Maybe it was beyond the law there. And so the United States Supreme Court established procedural due process rules. And individuals find themselves in a process where they have a right to have a trial. Now, you can also find yourself in a situation where you waive that right to a trial by pleading guilty. Okay. Now, a lot of this stuff here, the Supreme Court and the procedural due process, don't get confused. Because some students do, when they look at these cases. These are older cases Murray's Lacey versus Hoboken Land and Improvement. This is a case involving um, embezzlement and um, warrants issued. And so the court takes the position that the Constitution didn't specify what due process was. So who determines what due process is in terms of application are the actual cases themselves, okay? So it says here, just a little bit of stuff for you. It involves an actor, plaintiff, a defendant, and a trier of fact, the judge. The defendant is notified of the allegations. I told you that. Provided with the opportunity to answer those. I told you that. And then a trial is afforded. Okay. And then this tells you about the due process application, hearing, the accused provide notice, opportunity, present reasons um, uh, to why the proposed action was not correct, the right to call witnesses, attorney, hearing, written statement of the reasons, that's the indictment or information, and then it's public attendance, unless it's a juvenile court, okay? So procedural due process is very important in what we call fundamental fairness and as jurisprudence, protecting the rights of the accused is essential and required by the first 10 amendments. And it says in holding defendants accountable, the procedures are also established to discover truth. And we want to try to prevent one innocent person from being punished for a crime they did not commit. So each state has different processes, but the Constitution overall determines it. Okay. And let's go down here to the knowledge check just for a moment before we adjourn here. So you can go back and you can check these things. Which amendment prohibits double jeopardy? The 5th, the 6th, the 4th, the 8th. Some people think this is it. That's cruel and unusual punishment. That's search and seizure. That's speedy trials and attorney. It's self-incrimination and double jeopardy. Okay, and it tells you here. Which amendment provides the right to remain silent? We already covered that, so we'll put that in there. And then you can go on. What elements must be present for the right to remain silent to apply? Arrest for an ordinance violation and subject to questioning, for a crime subject to identification question, temporary detention, arrest for a crime. How about that one? That's it. The other three options do not include all three elements as we discussed. So that you can go through and you can look at that. Okay. Well, I've covered everything that we need to cover. And the only question left over is what is the key phrase? And the key phrase is self-incrimination. Give me self-incrimination and you will get your points for this week. Okay, this has been Professor Richard Wright. And again, if you have any questions, feel free to reach out to me. Remember what I said at the outset of this, there's some students who need to step up their game. Those of you who are doing well, keep doing well. And if you have questions, feel free to reach out to me. All right, so have a good week. I will see you next Monday. Next Monday will be the 2nd. Okay. See you then. Enjoy your week.